CryptoDrew Channel. My name is Andrew, and today we are talking about the SEC v. Ripple Labs Inc. lawsuit, which is causing more than a ripple in the crypto community. The U.S. Securities and Exchange Commission, or SEC for short, is an independent federal regulatory agency that is responsible for protecting investors. They were established by Congress via the Securities and Exchange Act of 1934, which was mostly a response to the stock market crash of 1929 that led to the Great Depression. The Great Depression saw a 90% drop in the stock market over the next 2.5 years, until it finally bottomed in the middle of 1932. So I can certainly see why they wanted to prevent that from happening again. And, billionaires want to stay billionaires, or however rich they were back then, maybe like thousandaires or something. Ripple Labs Inc., originally named OpenCoin, is an American technology company founded in 2012, which developed the Ripple Payment and Exchange Network. The company also developed its own form of digital currency, referred to as XRP, which allows financial institutions to send money with negligible fees and negligible wait time. Unlike most other cryptocurrencies, XRP does not require a transaction fee per se. Instead, it requires the sender to burn a very small portion of the XRP being sent. This means that XRP is deflationary, which is good for the price over time since the lower supply should lead to higher demand and a higher price. But don't get too excited since at its current burn rate, it would take 70,000 years to burn the entire supply. That's a long time. By mid-2020, Ripple distributed and sold $1.3 billion of its XRP asset, which they consider to be a digital currency. However, the SEC does not. On December 22nd, 2020, the SEC filed their case against Ripple, arguing that the company and two of its executives participated in an unregistered securities offering of that 1.3 billion XRP. This immediately resulted in a $50 billion crash in the cryptocurrency market. Yikes! Jay Clayton, the chairman of the SEC at the time, resigned the very next day. Talk about mic drop moment for your last day in office. So what is a security anyway? Traditionally, a security is any financial holding that represents either a stake in a company or a debt that the company owes to the holder of the security. And these are typically represented in the forms of either stocks or bonds. And the purpose of these securities is always as a way for the entity offering the security to be able to raise capital. In 1946, the court case of SEC v. W.J. Howey was escalated to the Supreme Court, where a broader definition of a security was taken under consideration. This case involved the sale of citrus groves by the Howey Company, where the buyers would lease the land back to the Howey Company, and the Howey Company would farm the land and share the profits with both parties. That was nice of them. And since the buyers of the land were not expected to have any agriculture experience and were not expected to farm the land, this was saw as more of an investment contract for them, where they would be expecting to make profits through the actions of another party. The Howey test was established during this case as a four-pronged approach for identifying securities such as this. The test states that an investment contract is 1, an investment of money, 2, in a common enterprise, 3, with the expectation of profits, and 4, to be derived through the efforts of others. This case opened the door for almost anything to be considered an investment contract or a security. Courts have already enforced securities provisions on such things as whiskey, beavers, and chinchillas. Sounds like a receipt for a really fun party if you ask me. One thing that cannot be considered a security is currency. The Securities and Exchange Act of 1934 specifically states in its definition of a security that it shall not include any currency. And perhaps this is where Ripple's defense lies with its XRP. Ripple responded to their lawsuit by stating that
the complaint filed by the SEC advances an unprecedented and ill-conceived legal theory with neither statutory mandate nor congressional authorization that Ripple's distributions of the virtual currency XRP constitute investment contracts and thus securities subject to registration under Section 5 of the Securities Act of 1933, 15 U.S.C. 77B-A1. That theory ignores, among other things, that XRP performs a number of functions that are distinct from the functions of securities, as the law has understood that term for decades. For example, XRP functions as a medium of exchange, a virtual currency used in today's international and domestic transactions, moving its value between jurisdictions and facilitating transactions. It is not a security, and the SEC has no authority to regulate it as one. Before this case, no securities regulator in the world has claimed that transactions in XRP must be registered as securities, and for good reason. The functionality and liquidity of XRP are wholly incompatible with securities regulation. To require XRP's registration as a security is to impair its main utility.
Is Ripple correct to call out that the SEC should not be the regulator of authority on cryptocurrencies? And if not the SEC, then who? In 2015, the Commodities Futures Trading Commission, or CFTC for short, claimed cryptocurrencies are legally classified as commodities, so they should be the regulator. It's convenient for a government agency to just appoint themselves as the regulator, but now we have two government agencies both claiming that they are the regulator. When people start buying their prescription medicine with Bitcoin, will the FDA say that they should be the regulator? When the FCC starts noticing that people are advertising for cryptocurrencies on the radio, will they claim that they should be the regulator? When will this regulation madness and confusion end? Fun fact about the FCC is that they were also created in 1934. That legislature really had a case of regulator fever that year. It was the summer of regulator love. Maybe we could just erase 1934 from the timeline and then solve all of our regulator problems? Or maybe travel back in time to 1934 to convince that legislature to create yet another regulator? This time for the cryptocurrency asset class? And it really is a new asset class, and the existing regulators just don't have the structure to define it properly. They're trying to fit the square-shaped peg of crypto into the round-shaped hole of securities and commodities. Or should I say the block-shaped peg of crypto, since it lives on the blockchain? Perhaps Charles Hoskinson, co-founder of Ethereum and founder of Cardano, summarized this best. He said, "The problem with cryptocurrencies is that they do everything and nothing. Some days they look like securities. Some days they look like commodities. Some days they look like currencies. And some days they look like something else entirely." Anyway, please send some love to your friends in the XRP army as they are trying to survive this regulator chaos. Thanks for sticking around. Please like, share, subscribe, and I will catch you next time.